Once again, thanks for joining. And as everyone knows, today we're really talking about the Cybercrimes Act. Just for a brief recap on where we are, the Cybercrimes Act was actually signed into law last year, but late last year, parts of the act have actually commenced. So that means that our law is in full effect. And it's really important, and we feel that this law is very necessary simply because now that means that we have an active and robust comprehensive law that deals with cybercrimes and cybercrimes related issues. So this is great news, and it's a long time coming. I know we've been heavily involved right from the beginning when the act was still a bill. So it really is a relief that we have a law that deals with this. But now we're thinking about the next step. We really want to understand, and you're probably asking yourself, what actual effect does this law have on me and my organization? And today our distinguished panel is really going to unpack those key issues from different perspectives so that you can understand how the act applies to you. So just to situate you, it doesn't mean that this act is really about giving the history. We're really looking at the practical aspects for each specific group. So today with me, we have our managing attorney, John Giles. We have our attorneys, Nathan Ross Adams, Shema Sheikh. You also have me, Lisa Imaiwaha, as your host. And we have Dion as well, helping us with the questions and answers. So as you've seen there in the chat, Dion's let you know that you can pop questions into the chat, and we'll try and address them at the end of the session. But make sure that you keep the questions really aligned to what we're discussing today, and that's the Cybercrimes Act. So let's get started. So the first thing that we want to just make sure is that everyone's on the same page and up to speed with the Cybercrimes Act. So Shema, can you just let us know what's new with the Act, what has changed, where are we right now?
Right. I think morning, everyone, and it's lovely to see that we've got a nice crowd. Where I'd like to start is to quickly share my screen. I think it's going to be the best way to talk about what's happening with the Act. So panelists, can you all see? Great. All right. So you can now view the Cybercrimes Act as a web page, which is really useful and nifty. So if you go to cybercrimesact.co.za, you can view the Act. And you will see here on the cover page, we talk about the different sections that have come into operation. So generally, the commencement date was the 1st of December, but only certain parts of the Act has commenced. So more importantly for this session, what I want to talk about is Chapter 2, because you'll see only parts 1 to 5 has commenced. And there's we'd like to talk about what the implications of that is. And you'll see Chapter 2 basically talks about different cybercrimes. So the Act, now that it's in effect, what it means is that certain crimes that have been mentioned in the Act are now recognized, and there are crimes, for example, malicious communications. But the fact that Part 5, Part 6 is not yet in operation, it does tend to indicate that it's unlikely that we'll see anyone prosecuted for crimes this side of the year, unless these parts start to commence sometime this year. But yes, go and have a look, and you can browse the Act.
Great. Thank you so much, Shema. And that's quite interesting because, as you said, the crimes are now all, existing crimes in law, but parts that really give effect to it haven't commenced yet. So it's going to be quite interesting to see how courts tackle this kind of situation.
There's a post that we published, and I'll pop the link in the chat just now, about malicious communications being a crime. And what I'd like to say is that, you can actually get around it, because under the common law, even though you can't get protection orders to protect complainants from harmful effects of malicious communications, under the common law, you can get protection orders against people for certain crimes, like harassment and things.
That's a great point, Shema. And we will be dealing a bit more with malicious communications, particularly how it's addressed with individuals and parents and those kinds of interest groups. So Right now, we're going to look at what kind of organization you are and essentially understanding who you are. So this part of the webinar will deal with different groups, and we'll look at what it means practically for each of those groups. So what I'm going to do now is to run a poll just to understand exactly who you are. And you should just tick and choose the option that applies most to you and your context. So we'll give it about 30 more seconds more, and then we will publish the results. Great. So I'm just going to end the poll and I will share the results. And it's quite interesting to see the spread. A lot of it is kind of expected, but other things are quite interesting. So the majority of you, as we thought, you're a private organization. So that can be anything from a media house to just anybody who's selling goods and services to regular people. Some of you, 25% are financial institutions, which makes sense. You might be a bank, you could be a credit provider, you're providing some kind of financial service to others. We also have a decent spread of ICT companies. You could also be considered an ECSP, and we'll delve into that a bit more. So that makes sense as well. And it's key to understand because we'll talk about it, but ICT companies, ECSPs, and financial institutions have specific requirements in the Cybercrimes Act. Some of you, a small percent, are individuals, of course, and all of us are, at the end of the day, just regular people. So there is an impact on us from that perspective. And we do have some from the public sector, public bodies, as well as law enforcement or the judiciary. So it is quite a decent spread, and we are dealing with different interest groups here. Interestingly enough, no one has answered that they're a parent, but that is also linked to individuals as well. Great. So as we stated, we are going to look at each interest group and to just unpack really how the Cybercrimes Act practically affects them. And the first one, and the one that most of you all are, is a private organization. So as Shema mentioned, the Cybercrimes Act is now in force, and parts of it are in force, which are the parts related to crimes. So there are many new crimes created by the Cybercrimes Act. It can really deal with things like criminalizing the unlawful acts done to computers, networks, or data, or unlawful acts done using computers and other tools. So the first type of crime we really want to look at is the crimes related to data, and particularly personal information. So that bears the question, will you get in trouble if you don't protect personal information in terms of POPIA? John, we'd love to hear your thoughts on this.
Thanks very much, Lisa, and good morning to everybody. Great to be here. Yeah, I think looking at the practical impact of this law, at its very heart, it creates cybercrimes. It creates crimes that relate to data, computer systems, and really IT. And that's really interesting for all of us, and it's practically going to impact us because we, no matter who you are, could commit a cybercrime. The crimes are all phrased as any person. So it's any natural person, it's any juristic person. So your organizations could commit a cybercrime. You personally could commit a cybercrime either in your organization or at home, or in just your daily use of your computer or your phone, or what you do with data that you get access to. So that's the one impact is that, we need to be saying, okay, great, what are these crimes? I don't want to be committing them. The penalties are significant, and I don't want to commit one of these crimes. So I need to work out, and also for many of you, I think will be saying, well, I don't want my organization to commit these crimes. So we need to know what they are, take steps to try and make sure we don't commit them. And then the flip side of that coin is that cybercrime is a massive problem in South Africa, around the world, but particularly in South Africa. And there are many cyber criminals who are causing lots of harm to many people. And so this act is very welcome from that perspective, in that hopefully it'll help us catch criminals. Hopefully the prosecuting authority will prosecute and punish criminals. That's what we want. You know, we can debate that in the South African context. I know currently there's a big debate around corruption and the lack of prosecuting people for corruption. And as South Africa, we don't have a very good track record of catching and punishing criminals. We just don't. So I'm not sure if a similar scenario will happen here, but certainly having the legal framework in place that will enable us to try and catch and prosecute criminals is now in place. And hopefully it will have an impact in reducing cybercrime. So those are two real practical implications. And you know, I was thinking about, many of you are private organizations, and think of a scenario where a hacker hacks your systems and takes a whole lot of personal information. What that means for your institution is that you're going to have to kick off your incident response procedure, go through breach management. You're going to have to notify regulators, data subjects. It's a massive impact on you. And it's really a criminal has caused all that damage, work, reputational damage, and then the harm that'll be suffered to the data subjects as well. So many of you, I think, are going to be saying, great, well, let's use this law. Hopefully it really helps us in catching those criminals. So then, yeah, to get back to really to the data crimes, what I've really wanted to do, and what I pride myself on, is being able to explain things simply. And I love getting to the kernel of things. I love being able to break something down. I love being able to understand it and come up with practical examples. And so we spent a lot of time looking at these data crimes, trying to simplify them, trying to explain this is what they are. And unfortunately, it's very, very hard. And that's part of what I want to demonstrate to you today, in that I'm really worried that the scope of these crimes is so broad that it makes virtually all of us a criminal. And I'll demonstrate why I think that is the case. And I also worry that, well, there's some negative consequences that come from that. Also, I worry that it's going to be difficult to catch cyber criminals because the crimes themselves are so vague. I think that it's going to be very difficult. So let me, I thought I would present, starting with a presentation and just a few key concepts, and then look at some of the data crimes specifically. So I'm going to share my screen and go to this presentation, which is a presentation we use for many of our workshops and our presentations, our executive briefings. And I'm going to zoom in here to the crime section specifically and talk a little bit about the scope of the crimes, because there's certain words that apply to all the crimes and really help us unlock what they mean. So the first point I wanted to make is that we live in a free country, and we should be free to do most things. That should be the default position. So we should be able to do many things, particularly with data, with computers, with computer systems. We need to be able to use them in order to do lots of things. I don't need to talk more about that, but there does need to be a balance, and there needs to be some control. And so lawful conduct is that which is allowed or not prohibited. Unlawful conduct then is a smaller group, which is saying, and this is particularly important, unlawful conduct is prohibited or not permitted by law. So it's any law, including the common law and statutes, And the bit about or not permitted is very important for public bodies, because public bodies are creatures of statute and can only do what they're permitted to do. But essentially, unlawful is its conduct that's prohibited or not permitted by law. Then certain unlawful conduct is criminal conduct, or it's illegal. And there's a difference between unlawful and illegal, unlawful and criminal. There is a difference between that, which is very important. But then for some crimes, there's a defense. You can raise different defenses, and therefore it's not criminal conduct. But the way I've drawn this Venn diagram is largely how it should be. Most things should be lawful, some should be unlawful, and then a few things should be criminal. Using the criminal sanction is an extreme scenario, and it's really what parliaments and society uses to try and stop people doing really hurtful or harmful things. And the criminal sanction brings in the prospect of jail, and it's the prosecuting authorities. And a good example here is that in the workplace, it shouldn't be criminal. It's not criminal conduct. It might be unlawful conduct that somebody's accused of, but often the workplace is criminalized, which it shouldn't be. Also, data protection is a great example. Data protection has conditions for the lawful processing of personal information. If you don't comply with them, it's then unlawful. There are only a few crimes in data protection law, very, very few crimes, and that's intentionally done, and it again illustrates the difference between the two. What we want to watch out for is this scenario where virtually everything becomes criminal conduct, and you're prevented from doing anything because it then makes us all criminals. And people then have to prove that they're innocent. This is the scenario where we want to guard against. So crimes need to be specifically defined. They need to be clear on what it is that you can't do. And you should be able to read it and go, oh yes, I get it, I can't do X. They need to be clear. So I think the solution is this scenario that I mentioned. We need to be precise in criminalizing conduct, and by doing this, we stop things like selective prosecution, because if we're all committing crimes, then you can choose who you're going to prosecute, which can have a significant impact on people. So that's a bit of a background. And now I want to go to some specific crimes. And so on the left here, I've got the law. This is cybercrimesact.coza, and I'm at section 2. On the right-hand side, I've tried a plain language section 2. So if we look at this, this is about unlawful access, and let's go to 2A. So let's go over here and start there. So it's any person who unlawfully, so there's the word we've just been talking about, that's really key. And intentionally, those words always come up. I think intentionally, there's reasonable clarity there. Intention, you intend to do it, you meant to do it, whereas negligently, you're saying, well, I didn't intend to do it, but I should have known not to do it. And so you've got intention and negligence. You've got to have done it intentionally. So it's any person who unlawfully, so not permitted by law, or not enabled by law, accesses a computer system or computer data storage medium is guilty of an offense. So both those terms are defined and are very broad. So it's about accesses. That's the important thing. Then for the purpose of A person accesses, and it goes into certain things. And then it goes into, for the purposes of B, a person uses, because they use the word uses there. I mean, if that's not an example of complex cross-referencing and terrible drafting, I don't know what is. How is somebody meant to work that out? So on the right here, I've tried to plain language it. So for me, essentially what it's saying is that any person who unlawfully intentionally accesses a computer system by copying or moving data or storing data is guilty of an offense. Now, I intentionally access a computer system by doing those things all day, every day. So the only thing that stops me is if it's done lawfully, I'm okay. If I do it unlawfully, I'm not okay. So in order to know that, I need to know all the laws that relate to accessing data. Now, that is a huge ask, absolutely huge ask, and I mean all laws. So I hope that illustrates to you how vague and how broad the scope is of that section. Nathan, do you want to jump in here?
Yes, John. Just on your point about unlawful access, there was someone asked a question, Clinton, about ethical hacking and penetration testing, security penetration testing, and in that case, presumably the ethical hackers would have an agreement with the company to actually do their security testing and penetration testing as well. And so that access to their system would be a lawful act of access. But there was an instance in the US recently where a hacker hacked Tesla's autonomous vehicles that they have, but he did it as a sort of boastful attempt to show his hacking skills. In that case, it was unlawful access. If that were to happen here, it would be classified as a cybercrime. And just to John's point about the various laws, the way the act reads, the expectation is that you're not only aware of the Cybercrimes Act, but also POPIA, PIA, RICA, ECTA, all of those laws become part of the conversation of this act, because it sort of takes an umbrella position over any potential piece of legislation that deals with data.
Thanks, Nathan. Yeah, really good points. I mean, we, as Lisa mentioned, we were part of a group of people who really fought hard against the early versions of the Cybercrimes Act, because there was even a reverse onus on ethical hackers to prove they were innocent. So in other words, if you were caught hacking, you were assumed to be guilty unless you could prove that you were doing it ethically. So we managed to get many of those things out, but this section 4 still really is trying to address that scenario of ethical hacking, but a lot of contents come out and a lot is now left under this concept of unlawfully. There was a concept of unauthorized, which has been taken out of the final version, which really spoke to that scenario of I'm hacking a system, but the owner of it authorized me to hack it because I'm an ethical hacker. But Nathan, you're spot on. It's all in that concept of unlawfully. And there's going to be so much to unpack in that word of unlawfully, which is really going to be tricky. So I think I'm conscious of time, but so let me show you, I think, one other. So there's this that I think is important that I mention here now, is at the end of section 1, it's kind of hidden away, but what they specifically say down here, and let me maybe make that a little bit bigger so that you can really see it. But it says, for the purposes of certain crimes, any failure by a responsible party to comply with the conditions of lawful processing, Chapter 3 of POPIA, Section 72, or a code of conduct must be dealt with under POPIA and not under this law. So they were trying to say, okay, there's a chance, or there's a good reason, the argument that the Cybercrimes Act criminalizes this conduct under the POPIA, and it shouldn't, so we're going to carve it out. The problem is this only relates to POPIA. What about PIA? What about access to information? What about record retention laws? What about all the other laws that Nathan mentioned? It's still, in my view, a real problem. And I think the best way to demonstrate this is let's go to, sorry, just give me a sec. So let's go to this cybercrime, which is around, it's 5. So here we've got any person who unlawfully and intentionally interferes with data or a computer program is guilty of an offense. So I intentionally interfere with data and computer programs. It all depends on what interferes means, and we've got that lovely word unlawfully again. So then it starts saying here, well, for the purposes interferes means, and then it's got this list here. For me, the plain language version of this section is this. So any person who unlawfully deletes data is guilty of an offense. So, I mean, so there's a record retention law that requires you to retain a record, which includes data for 5 years. I intentionally go and delete that record because I think that it's 3 years, not 5 years. That's unlawful. Therefore, I've committed an offense. Let's see, a person who unlawfully and intentionally denies access to data. So someone puts in a POPIA request and I say to them, no, sorry, I'm not giving you access to that data because I don't think that or there's a ground for refusal, but I get it wrong. So I've now done it contrary to POPIA. It's therefore unlawful. I've therefore committed an offense. And that is, for me, this is just way, way too broad. We're all going to be committing these crimes. And it's just crazy. So that I think is enough from me for the moment. Let's go back to Lisa.
Thanks, John, for the thorough explanation as to the interplay between Cybercrimes Act and POPIA. And I think it's a key point that both Nathan and John mentioned. You have to understand that it's not just the Cybercrimes Act you have to look at when it comes to determining if you've committed a crime. You also have to look at other acts that deal with certain things. We've mentioned POPIA when it comes to data protection. We've mentioned the POPIA Act when it comes to access to information. So there has to be an understanding of the relationship between these kinds of acts, and therefore that will let you know if you've committed a crime or not. So really, and something that I just want to emphasize here is that we're showing you a lot of crimes, and that's because the Cybercrimes Act is a criminal law. You shouldn't treat it the same way you would treat POPIA or any of the other laws, because those really are principle-based and deal with compliance. This is a criminal act. This is about prosecuting crimes. So the simple answer really, and a good way and a great tip when it comes to thinking about the Cybercrimes Act is if you comply with these laws like POPIA, PI, etc., and do what you need to do, then it's unlikely that you would be in breach of the Cybercrimes Act. Shema, I see your hand is up.
I just want to piggyback on what John and Nathan were talking about, the wording in the act about it being, unlawfully. And what really concerns me about that is, the application of other laws. How many people that aren't legally schooled actually know that they're committing a crime? Because we've already established, I think I'm skipping ahead because we are going to be discussing malicious communications in a bit, but we've already established in that post that a Facebook post could be is definitely a data message, and there were court judgments that came out recently where someone felt threatened by inflammatory language used as part of a Facebook post, and they obtained an interdict to have the post taken down. And I just think it's got severe consequences for the man on the street, especially when they don't realize that they're committing a crime, and they don't behave responsibly online.
Thanks, Shema. John?
Yes, Shema, just to add to what you're saying, I totally agree. It occurred to me last year, particularly during the riots, that On Twitter, people were committing the crime of a malicious communication every minute. I mean, it was just on the Twitter feed. It was just, there's a malicious communication, another one, another one, another one, another one, another one. So again, if you've got a scenario where, if you go to the wording of that crime, and it's very important with crimes to go to the wording, because every word matters. It's very, very important, and they're interpreted very strictly by the courts for good reason. And if you go to the wording of malicious communication, it's very broad, and literally there are thousands of crimes committed on Twitter every single day.
John? So the key aspects that John and Shema have been talking about are related to malicious crimes, and we'll tackle those directly when we look at how Cybercrimes Act deals with individuals. So what I want to quickly do is to just run a poll just to see what your thoughts and feelings are and concerns when it comes to being a private organization. So are you concerned about essentially how the act will affect you? You can choose any option that applies to you and multiple options as well. So those are just some things to consider from a private organization. And I think someone mentioned it in the chat that a key aspect to this and some important issues to consider is understanding, as John said, what the crimes are and how it affects you. So there needs to be a level of awareness and training for people to really unpack what the data crimes are, what the crimes in general are in the Cybercrimes Act. So another key aspect is just to really understand how to deal with incidents and to make sure that incidences include things about the Cybercrimes Act, because sometimes we're quite narrow and only thinking about it in a data protection context, but we need to be broader and think about those key aspects. Anybody else with some key tips and practical tips that can help?
Lisa, may I go ahead?
Yes, please.
Okay, perfect. One of my concerns from a commercial perspective, as I see that is the interest of most of the attendees on the call, is from a transactions or contractual perspective. What many people, I think, may have slipped many people's minds is the fact that in most contracts, there's a special clause or a few special clauses where you agree to conduct yourself lawfully, to comply with laws. And you also generally make warranties and indemnities saying that if my organization or my personnel performs an unlawful act, that I'll indemnify you. So I'll ensure that if that event happens, that I'll be liable. Let's just say that happens. Now, the Cybercrimes Act forms part of that unlawful activity, as we mentioned. So tracking the compliance of your organization and your employees, directors, wherever they may be, becomes more important, because breaching the Cybercrimes Act would actually activate those clauses in your agreements, making risk more difficult to assess. That's why I would advise that organizations start relooking at certain key documents, contracts, policies, for example, an acceptable use of IT policy, their information security policy, about how they want their employees to engage on platforms where cybercrimes can be committed, but also where you have, say, for example, you have an application or platform and you have various users on there. You don't want to be liable at the end of the day for what the users do on the platform. So it's important to have acceptable use standards and policies in place for that. Thanks, Lisa.
Thank you so much, Nathan. Shema?
Just to dovetail on what Nathan spoke about now, it's a really important issue. And I think yesterday when we were talking about this, we said that we could probably have a whole discussion on its own about the effects of the Cybercrimes Act and in the workplace setting. What I wanted to say was that, it's not a new concept, because we have seen several labor laws judgments in the past where employees have been dismissed for, posting offensive material on their social media platforms. So if you participate online in discussions and it is picked up, then, if your workplace policies prevents this type of behavior, then you can be sanctioned for it.
Thank you, Shama. John, I just want to check if that's an old hand. Yeah, it looks like it's an old hand. Thank you very much.
So,
and
it's an old hand.
okay, great. And then I'm going to end the poll and let's share the results. So the spread is quite as expected. One of the key things everyone is interested in is understanding how the act will affect your general compliance, because you've already probably done some POPIA compliance, some other kinds of compliance, and you think, is this another project? Is this something else to add? But you, once again, should not see it that way, because this is a criminal act. There might be some key things that maybe financial institutions and ECSPs need to do, and we'll touch on that just now, but it's not another project. It's not another program. There can definitely be some instances, as some people have highlighted, where there might be some additional costs to the organization, particularly if you have a specific obligation coming out of the act. Of course, one of the most important things is understanding who committed the crime. If employees are committing cyber crimes, as Shama mentioned, that can be a whole topic in and of itself, and who is actually responsible. And let's just take a step back here, because John has mentioned something key about how this act is drafted. It says a person, and a person is defined as either a natural person, so you or me, or a juristic person, so a company. So it depends on who said person is who commits the crime. That person would be responsible. And key other things that you're interested in is what happens if you don't know or you don't understand the other laws that can affect the Cybercrimes Act, which is key. There's a lot of overlap. And not having the actual measures in place, like Nathan mentioned, your policies, your security, your contracts. So those are definitely key things. And of course, going to jail, how long it will take to align with the law and stuff like that. So definitely, I'm sure these are concerns everyone has, regardless of if they're a private organization or not. So the next body we are going to look at, I'm going to try and look at both because they have kind of similar obligations. We're going to look at the responsibilities and the impact of financial institutions and ECSPs. So as we know, financial institutions are in a highly regulated industry. Whether you're a bank, a credit provider, or even an insurance provider, you already have existing obligations, and a lot of them already. So from the panel, can we discuss a little bit about the practical impact on financial institutions? I know that the law has a specific obligation for financial institutions and ECSPs. Anyone can take this one. Or I can start us off. So one of the key obligations that financial institutions have is that they have to report any incident that they become aware of and report that to the police within 72 hours. So that's one obligation, reporting. The next one is that they also have to preserve the information, data, etc., related to that incident. And if they don't comply with those two requirements, it is actually a crime, and they will be charged 50,000 Rand. So this is also an obligation on ECSPs. So that is anybody who provides an electronic service with a license. So think about your mobile network providers, some types of IT companies, etc. So they have the same obligation. And that's really tricky when you think about it, because first, you might already have reporting obligations in terms of your existing policies, but have they considered what the Cybercrimes Act says? You might be thinking, oh, I only have to do reporting in terms of POPIA from a data protection perspective, and that is to report to an information regulator. What about the police when it's an actual crime that's committed? Because, we've dealt with throughout the years different data breaches, but are they crimes as well? Those are the kinds of considerations you have to think about and make sure that you're reporting within the time period. And then the next key thing is related to the preservation of data. Imagine preserving all of the data that you deal with. As a financial institution, I'm sure there are a lot of incidents that happen concurrently all of the time. Imagine how much data they have to preserve. There are no key guidelines right now as to how much data you need to preserve, how long you have to keep it. Does that mean I have to get a whole database, a new server? What am I doing? So those are the key considerations from a financial institution and ECSP perspective, especially when they want to comply with those obligations. Panel, anything else to add?
Yeah, from my side, Lisa, so the principle is that, and it's interesting just seeing Irene has mentioned that she's been a victim of identity theft and struggling to take action. And this is something that's happened in the past. So what Parliament is doing is ensuring that electronic communication service providers like an internet service provider or a financial institution like a bank, who often they're the ones with the evidence, the audit trails, the records of what actually happened, which enable a victim to or the prosecuting authority to prosecute a criminal. So the Cybercrimes Act now places a lot greater responsibility on those people to be watching for crimes, to report crimes that they notice happening over their networks, and then to retain the evidence that can be useful in prosecuting. So it is a big change. If you think of the mere conduit principle under the ECT Act, where often service providers said, no, I'm just a mere conduit. I'm just Twitter. I'm just a conduit for what's happening on it. I didn't commit that malicious communication. I'm just the conduit. This is now changing that slightly and saying, no, hang on a second. You have some responsibilities to be reporting crimes and storing evidence relating to them.
That is an excellent point, John. It's a lot more obligations that maybe people aren't used to, and now having to navigate those, especially if you don't want to commit a crime. Shema, I see your hands up.
You guys know I read a lot of judgments. So here's another example. And it's not something new. So the stage for electronic communication service providers to step up and cooperate in the process has already happened. So in the past, we've had quite a famous judgment, the one of Makanya. I'll drop the link in the chat just now. But he was receiving phone calls, at odd hours of the day, and it was really becoming an irritation. It was bothering him a lot, to the point where he deemed it as harassment, and was coming from a private number. And the service provider was ordered to disclose the details of the caller to him, and that was in terms of POPIA.
That's really interesting, Shema. That raises a great question, because what would have happened if the Cybercrimes Act was in effect? Who's getting prosecuted? But he had to rely on other things in order to at least lessen that harassment and make sure that it doesn't happen to him again. Thanks very much for that point. Nathan?
Yeah, I just wanted to speak briefly about the obligations of financial institutions. And just specifically, well, my point is very short, but it's with POPIA, financial institutions could rely a lot on the existing infrastructure to sort of say they're in compliance with POPIA, because they have certain technical and organizational measures in place. They do have what we call bank security when it comes to how they process information. But what I'm predicting is that with the Cybercrimes Act, they'll have to look at their processes under more scrutiny to see where there may be incidental, accidental breaches of the Cybercrimes Act. So things that they wouldn't have had to think about before. I mean, we all know financial institutions are prone to lots of different cyber criminals, and it's increasing. And so I think there's going to be a bigger responsibility on these organizations to play an active role in preventing that. So I don't think just alerts to customers are going to be enough. They are going to have to look at their internal processes as well.
That's a great point. Now they have to be more proactive. And I think that's something that all of you have been harking on is that you have to be active in this. And it's not just about responding to an incident, it's about how you address it in the beginning, prepping and knowing how to deal with an incident should it happen. So that's a really key thing to deal with. Shema, I see your hands up.
I just wanted to comment. I think, the Financial Services Conduct Authority, hats off to them for doing this really well over the years, because they're really quick and very responsive in, flagging any breaches that occur, anything irregular in the industry. It's usually flagged, and it's on their website, and you can follow. It's so accessible.
Great. That's a very interesting point and a great thing to add. And when we think about this similar obligation, something to just dovetail here when we think about ECSPs and ICT companies, since they also have this obligation, we also have to think about the crimes that affect them. And it's something that John mentioned earlier when we were looking at the data crimes. So a lot of ICT companies might be selling software and tools that can be used to commit crimes. How can they address that? Are they going out of business? Should they stop selling these tools? I don't know, John, if you have some comments on that.
Yeah, no, not specifically, but I don't think they should stop selling the tools. It's like, that's your business. You're gonna have to work a way around it. And I think, again, there's the ambiguity and the sections that you're gonna have to work through. And particularly that concept of unlawfully. So when is it lawful or unlawful to be using that tool? And therefore, you're going to have to spend a lot of time unpacking that concept in the context of what you do.
Great, that makes a lot of sense. So essentially, they need to assess what the law says against what they provide and see if there's really any risks related to that. So that's definitely something to keep in mind as an ICT and IT company. So we're quickly just going to run the polls on financial institutions and IT companies, just to really understand what your concerns are from that perspective. Dion, I don't know if there's any questions related to what we've been discussing, any key ones that we can maybe address while the poll is running.
I'm sure, Lisa, there are quite a few, but a theme that keeps showing up is the issue of vicarious liability. So if an employee uses work equipment to commit a cybercrime, will the employer be held liable?
I think that we have to once again look at how the act, I see your hands up here, John. You can take it if you want to.
Okay, all right. So that's yeah, this is definitely an issue. I'd encourage you to go and look at the specific laws. I'm not going to be able to get to well, actually, sorry, let me just, so section 2(1) says that it's any person, and sorry, I've got a lot on my screen, so I won't share it, but it's essentially, it's a crime if you place somebody else in a position to commit an offense. And I immediately thought, yeah, well, the CIO, the IT manager, the company, the CEO, they often place people in a position to do certain things. So that section 2(1) concerned me, but the even bigger one is in part 3, there's the section talking about aiding and abetting. And essentially, any person who helps somebody to commit one of the other crimes in part 1 or 2, they're guilty of a crime. And so that really extends the potential criminal liability dramatically. So it's not really vicarious liability; it's a crime in itself, and that is really a risk for organizations, that they will be accused of aiding and enabling somebody to commit a crime. And so I think the argument also holds true if we keep with that Twitter example. If Twitter is enabling somebody to make malicious communications on an ongoing basis, surely Twitter is aiding and abetting. Yeah.
Great point, John. And Nathan, I see you want to jump off of that point.
Thanks, John, for raising that point. It actually brings me to just think about social media generally and the algorithms that they use. So social media often employs algorithms to boost certain content based on its popularity. And there was a judgment in the EU about 2 or 3 years ago where it involved a situation where someone had conducted a search on Google, and the results that had come up were unlawful. So the results facilitated unlawful behavior, and the Google's argument was that the algorithms and the search results that it produces are so far removed from their conduct that causation will be difficult to establish in those cases. So I think it would definitely apply to this scenario. We are going to reach interesting cases where we'll have these social media companies or anyone else who uses algorithms pushing their liability aside and saying they can't be responsible for something where they don't even understand what the algorithm is producing at the end. There's too much information to process. So I just thought that's really interesting.
That's a great point, Nathan. And it's going to be linking into us when we discuss individuals, because of course, social media is a key aspect where people might commit cybercrimes. So I'm going to quickly end the poll and share the results for you. As expected, a lot of you as financial institutions have the same concerns as private organizations, which we've mentioned before. Reputational damage is a key concern, of course, because you don't want to be the organization that has maybe people have committed cybercrimes within your organization and people are aware of it now and no one wants to use you for services. Not knowing whether you're committing a crime, of course, getting jailed and fined and losing customers. I just want to check your Shema, is your question or your point related to social media and individuals? Okay, you can go ahead.
So there's been quite a bit of activity in the courts around this. So a bit earlier on, a couple of years ago, there was a lobbyist that posted something really offensive, posted somebody's personal details on social media, and it was a religious organization. And, you know, the comments that came from the public was quite harmful. It was threatening in nature, and he was ordered to take down the post. But I think more recently this month, there was another Supreme Court of Appeal case that came up. It went on appeal, but what I want to talk about is what happened in the High Court, because the Supreme Court of Appeal didn't talk about it. The case is Smuts versus Botha. And we'll pop a link to that in the chat as well. But what happened was a cyclist was going past a farm, and he came across a baboon that was trapped in a cage. And, you know, he made inquiries to find out who the farm belonged to. And long story short, just by disclosing the person's name and a phone number, this lobbyist, a person who ran a conservation group, and he had a page on Facebook, he posted WhatsApp chats with this person to say that, you know, he has a permit to trap animals. But I think the outrage that it caused on social media was not anticipated, and there were lots of harmful inflammatory language that was used, and he felt very threatened, and he applied for an interdict, and the High Court granted the interdict, and parts of that post had to be taken down. But what I was a bit surprised about was that the Supreme Court of Appeal didn't even mention that part, that he felt threatened. And he said he feared for his family because details about his personal life and his family was mentioned in that post. And, you know, I just thought the Cybercrimes Act came into effect on the 1st of December, and had it been interpreted under that, then definitely malicious communications would have a huge part, because if you incite bodily harm to someone, then you can be held liable for committing a committing a cybercrime.
That's a great point, because it leads right into what we want to discuss about individuals. So you're sharing messages, you're typing messages, you're inciting people. What happens? Are you just going to, like you said, in that case, they didn't see it in the lens of the Cybercrimes Act, but what if we did? That would be very, honestly, groundbreaking in our country to see how we would deal with those kinds of things within the context of the Cybercrimes Act. And I think sometimes people just wonder, are they criminals for simply just sharing these messages? I didn't type the message, but I'm just sharing it to my followers and to other people. What are the consequences? And the act is quite clear. Shema, I don't know if you can add a little bit more on that.
So there's three things. It's if you send out a data message that incites, threatens, or discloses certain things. So if you incite violence, or if you incite, and it includes bodily harm to someone else, if you threaten someone else, including threatening them with bodily harm, or if you disclose an intimate image of someone without their consent, then those three elements constitute a crime in terms of the Chapter 2 of the Cybercrimes Act, which is a malicious communication.
Thank you so much for breaking that down, because as we've said before, please go and just read the sections and make sure that you understand what they mean. You know, we can unpack that for you as well, but it's clear that you have to really know what a crime is, especially in the social media and online context. Nathan?
Yeah, just a quick one. So when it comes to individuals and a social media context and general media context as well, it's important to read the Cybercrimes Act not only on its own, but also with with POPIA. So that is the Promotion of Equality and Prevention of Unfair Discrimination Act, as well as there is a new bill that's come out for the Prevention of Hate Crimes and Hate Speech bills. Those three work together to deal with online behavior, harassment, as well as hate crimes.
Thank you so much for that, Nathan. And one thing I'd like to add is that unlike most other laws, that have defenses. The Cybercrimes Act doesn't really have defenses. And the reason we raise this is because we think about things like media companies and the news. They might want to share these messages or images so that we are more informed. But by merely sharing it and things like that, could they be seen as committing these cybercrimes? Because it's intentional, but is it unlawful? Those are the kinds of things that our courts will have to grapple with and unpack. So I see that we're almost out of time, and I just want to run a quick poll just for us to really see and understand how you'd like us to help you when it comes to cybercrime. So you can just choose the various options that you want, whether you feel like the session was valuable, but you want to really unpack and understand what the crimes are, what the crimes related to malicious communications are, things about what you need to do in your organization, whether it's whether it's putting in policies and things like that, reviewing your existing policies, thinking about aligning yourself with the law through incident response, and maybe just making sure your security is up to date. So those are the kinds of things that you can just choose so we can understand how we can help you. Panelists, I'm not sure if there's anything else you want to add at this perspective or if there's any inputs.
From my side, Lisa, I think it's to reassure people that the Cybercrimes Act is not like data protection law. It doesn't require you to proactively do all sorts of things. You're not going to start a massive project for this, but there are some really important things to look at. And I think that what this webinar has highlighted is that there are lots of questions, there are lots of concerns, and there's a lot of navigating that needs to get done to make sure that you don't end up on the wrong side of this. And so I definitely think that further awareness training is a very good idea. just some questions saying things like, should we be complying with an ISO standard? Do we need to have policies? What are the deadlines? There aren't really deadlines for this law. It's more a case of preparing yourself for it. And it's not a case of complying with a standard and therefore you comply with the Cybercrimes Act. But it's interesting to see these results, and we've worked really hard to develop some really practical solutions to help you with this law. And now that it's been enacted, really now is the time to dig into this in more detail and really work out what it means for your particular organization and take the action that you need to.
Thanks very much for that, John. That really is an excellent point. So based on the results, it is very key that understanding the law and getting a level of training is what most people want and most people are interested in, and that was expected. And across the board, some of you want your board to be briefed, others want specific assistance when it comes to legal opinions. Some of you are really interested in information security, and that is a key thing because data protection sets out certain requirements for information security. The Cybercrimes Act does not, because once again, it's not really a compliance law. So we have a whole section and modules dealing with that in our data protection program. So if you want access to that, you can contact our support desk at support@michalsons.com, and they can assist you with getting onto the program. Of course, some of you are also interested in instant response and then reviewing your policies. But we're really at the hour, and I'd like to really thank everyone, all of our panelists, all of us here, for really helping people understand some practical effects. We touched on key aspects of individuals, companies, ECSPs, financial institutions. Unfortunately, we didn't get to touch really on public bodies and law enforcement, but a key aspect there is that, as John mentioned right at the beginning, public bodies can only act within a law. They have to be authorized within a law. So the moment they act outside of it, they would be acting unlawfully. And when it comes to law enforcement, something that we've seen is that law enforcement are grappling with this, grappling with how to deal with the Cybercrimes Act, how to deal with cybercrimes in general. So for them as well, they need the training and the capacity needs to be built within law enforcement to really tackle this. And since this is a new law, this will be an ongoing thing that law enforcement really has to get to grips with, because people want to be able to, if a cybercrime has been committed against them, they want to be able to prosecute people and get some kind of relief. So that is just the general trend we've seen, and hopefully it will improve. Panelists, any last words?
I think just from me, it's that yeah, we're keen to help you on this journey. I've posted a link into the chat of how we can help you, and there's lots of more information on our website. Please go and have a look, and we're keen to help and support you in tackling this piece of legislation.
Great, thank you so much, John. Thanks everyone, and we hope you enjoy the rest of your day. Goodbye.
Bye.